Crooked Fanny playing dirty tricks in the courtroom. She always picks, bending the rules. She'd know win, but I won't let her get under my skin. Down in Georgia, where the blues run deep, crooked justice, a secret they keep. But I see through her lies, I see the truth. Gonna make her pay for what she do. Fanny's got a reputation to uphold, but her tactics are shady. Story untold, she thinks she's clever, but I'm on to her game. I'll expose her ways and put her to shame.
Hey yo folks, and welcome. I am in a hotel room in due north of Indianapolis. Let's just say that. I've been to Delphi, Indiana today with Mo in the deep end, and it was interesting. Now, next door seems to be a family with kids, so I will keep my volume down. So I should maybe put my audio up a bit so you hear me better, but so I don't disturb the neighbors here. All right. Okay, so Delphi, Indiana was very interesting, especially how tiny that place is. If you watched the live earlier today, me and Mo, the disabled people, walked more or less from city center to the outskirts, back to city center to another outskirt in less combined 15 minutes. We noticed that the courthouse is in the middle. Then over here you have the sheriff's office, and in eyesight is Rick Allen's former workplace. And remember, between 2017 up to his arrest, not a single person said, that Rick guy looks like the bridge guy. Not one. But we are here for the Young Thug trial, and today it was more evidentiary hearings. And we will get there, hopefully soon, but the prosecution wants in new charges. Things that happened during pre-trial and the stabbing of Shannon Stillwell, the actual situation that happened during Christmas. How about that? And apparently they found drugs on different individuals. And yeah, that's bad, folks. That's really bad, because remember from a few days ago or last week, the prosecution only needs one person convicted for one overt act, unless they get out of the murder charge. But now you have charges that aren't, where the statute of limitation is more or less now. So yeah, they are still building a case. And in my opinion, my personal opinion, which sadly is according to Georgia law, is that if something happens during trial, have it on next trial, not bring it in. But apparently Georgia law kind of allows it. So, but we need to check today out. Now, I sadly have my converter, or the adapter is still in the car somewhere. It wasn't in my luggage, it wasn't in my backpack. Hopefully it's still in the car somewhere. If it's not, I forgot it somewhere. But I have, according to the battery time, about just over 2 hours to get through this today. So, let's start. Doug is back. That's good. And tomorrow I will be at Dave's place with everything I need there. So it will be much better. Maybe I should do one of these. Yeah. And allegedly, oh, they didn't start immediately now. Allegedly, today was the day where the prosecution got to get their course in how to present a case. Oh.
All right, so I think that maybe the first things we need to tackle are whatever the evidence is going to be with our next few witnesses following Mr. Copeland. So I know that co-conspirator statements, as well as all of the other evidence that y'all, the state, intend to introduce with the next several witnesses, has been provided now in detail. So I would propose that that's where we start, unless somebody thinks something else would be more efficient. That work for everybody? Okay, so have y'all been able to get together on any of it to come to agreement on anything, or are we going to litigate all of it?
Your Honor,
Yeah.
just for clarity, are we discussing the evidence that was shared by Mr. Atkins on Friday night? Is that?
I mean, I think there have been a couple of different shares. There was, I also don't, off the top of my head, know exactly when. There was one, and then there was a supplement, and then there's also, I think, something that Ms. Hilton shared that's in a spreadsheet, which I think covers the same things that Mr. Atkins provided already.
So, I think there's multiple, God bless you, there's multiple things. We sent the evidence regarding upcoming witnesses a few weeks ago, according to Mr. Atkins. What we sent on Friday, Your Honor, was the co-conspirator statements, making sure that the ones that the state intends to use were provided.
Yeah, and only almost a year late. Apparently, this judge keeps giving them chances to bring in stuff, which for me is, yeah, I don't. She has every possibility, Judge Whitaker, to tell them, well, sorry, but too late, move on. She has. She doesn't use it all that often, sadly.
And then yesterday, what I did was I provided a spreadsheet of the co-conspirator statements that are found within Mr. Garlington's wiretap, which had already been provided, and Mr. Sumlin's wiretap that had already been provided.
Okay.
So I just specified which statements from those wiretaps we intended to use.
Okay, so that's a subset of the bigger set.
Yes,
So,
Your Honor.
I mean, we can start there if y'all want to start there. Are Or are those going to come in later in the trial?
Most of those are going to come in later in the
Okay,
trial.
well then
Your
we'll
Honor.
set those aside for now.
And we submitted the 31 through 60 witnesses.
Right.
Oh, I'm sorry. We submitted the 1 through 30 witnesses on August 8th,
Right.
2024.
I don't know. I don't hear a rattle. If nobody else hears a rattle, Manders hears a rattling and Patty hears a rattling. I don't hear a rattling. So I don't know what that might be.
Okay.
Judge, there was one matter with respect to the PowerPoint. I did send over the redacted one. And I spoke with, as I informed the court, I spoke with Mr. Williams about Mr. Ryan's statement and our intent to not use that.
Right.
So those two matters were off the table.
Okay. So yeah, we don't have to deal with a motion to suppress Mr. Ryan's statement because the state does not intend to use that. And I've also been informed that Mr. Kendricks is not going to be filing a motion to suppress the first hour and a half or 2 hours or whatever of his statement. So we don't have, that's also off of our to-do list.
Your Honor, on
Yes.
behalf of Mr. Ryan, and what was received on Friday, I think was our updated list of the people they actually intend on calling and co-conspirator statements, I believe. So we'll have Mr. Ryan's motions in limine, the basic ones of this is inadmissible hearsay, those types of items based on what we just received. I don't know if those are the immediate upcoming witnesses. We're going to prepare it as fast as we can. We're just kind of, as you know, getting the rolling. This is what's actually being introduced. So.
And so we, in my speaking with Mr. Williams, I did let her know that if she had specific objections, there may be things that we could agree to. She did name some and I agreed with her. So we were continuing to discuss those. So if after those conversations, Ms. Abbasi and Mr. Williams feel like there's still more to litigate, that'll happen. But that conversation and that dialogue has started regarding those things that have been turned over to Mr. Ryan.
I think what probably would be the most productive is things that we have issues on, we make note of and make a record. This is the defense raises this issue, state agrees, so that they've been addressed and it doesn't, something got missed from the list or something like that. So we'll get with Ms. Love and do that.
That's fine.
We'll
that's
get
fine.
that to the court as soon as possible. I don't know if they are in the next few witnesses category or not.
I mean, I don't either right offhand, but if it is, we're litigating that stuff this week.
Right. Could the state provide a little bit of guidance?
No, Your Honor, the stuff for the Jamari Holmes are not within the next 10 weeks.
Okay.
Okay, thank you.
Witnesses.
All right. That works.
Thank you.
How about Mr. Kendrick's statement that there's the Bruton issues on, right? And when's that going to get introduced?
So not in the next 4 weeks, actually, based on who it is that we intend to come before the witness that would
Okay.
introduce.
What witness will that be with?
Investigator Thorpe.
Well, y'all got him listed as witness number 5.
We do, but he has had, he will be moved down based on some circumstances that have occurred in his,
Okay.
he has some personal matters.
Okay. So
Yeah, he has some personal matters because he was very, very buttered over being called a peanut brain or a squirrel brain by Mr. Copeland. I hope he shows up in his broad prison stripes. That would be so funny.
is it still going to be Burnett, Sledge, Zachary, Dean, Morton, Sprinkle, the phone custodians, Bernie, generally?
Generally, yes.
Okay. And then I guess Thorpe will be at the end of those now? Okay. And that PowerPoint, that's
with Dennis.
that's with Dennis. Okay. So he's several out. Okay. All right, so great. That'll give y'all some time to get together on that statement to sort Bruton issues. Mr. Steele, you also seemed to kind of be making a broad argument that nothing in his statement, in Mr. Kendrick's statement, even if it doesn't directly implicate your client standing alone, needs to be redacted, or there needs to be a limiting instruction about that. Do you have any law to back that up?
First, thank you, Kiana Shaw, for becoming a member. That is so nice of you. And now you have access to hello to all my members only content, members only emojis, and as soon as I find the time for it, members only Discord. I will post a link sooner or later on my community page. But meanwhile, enjoy members only content and members only emojis. And thank you for your support.
I'm trying to get proper law, but in this case, there has been over objection, the announcement that YSL is a criminal street gang that Mr. Williams, according to 3 supposed experts, is a member of, in addition to Trintavia Stevens, said that Mr. Williams is a member of, in addition to Mr. Walter Murphy, had Mr. Williams allegedly as a member of. There may be others. And then in Mr. Kendrick's statement to law enforcement on October 6th, 2015, he discusses YSL, the crew, the gang. So I think that under Bruton, it's an element of the offense of criminal street gang as well as RICO, that I believe that that does not indirectly, but directly implicates Mr. Williams. But I'm looking for law on that, but that I do not want to waive that issue. In addition,
Well, yeah, just get me some law and we'll take it. It sounds like it's not quite as time sensitive as we thought it was, but we still need to get moving on it. So try to get me the law that would cover that.
in addition, I'm sorry.
Go ahead.
No, I thought
Go ahead, I'm done.
you were done. Thought the zombie call was done. Yes, I do want a limiting instruction, and that comes right out of the cases that I did cite, because that statement I cannot cross-examine. Mr. Adams cannot cross-examine Mr. Kendrick. That statement should be his alone, and it's confrontation clause, so it does not move the conspiracy forward. So it's not a recognized exception.
Okay.
So the second part of the question was, do you have law for the limiting instruction? And I already provided. I could provide more.
Okay. And then I do want you to get with the state to try to come to an agreement as to what needs to get redacted to avoid Bruton, at least the classic Bruton issues. And we'll have to take up whether any kind of talk whatsoever about YSL gets included within that or not. But as to sort of the classic, Mr. Williams did this, which I doubt if he says something like that anyway, but something that would directly implicate your client standing alone. The state ought to know what that would be and be able to redact that out. And it played as a video statement, right? So, right or no?
We intended to ask questions
Okay.
versus.
That's fine. That's fine.
And Your Honor,
Yeah.
I did that in my motion. I was specific, and I give the timestamp where it starts. And I did it not only for Mr. Williams, but I did it for anybody else that I saw. And I did it for Shannon Stillwell. He's mentioned a great deal as well. So I believe that I flagged. If I missed anything, obviously, I'd like somebody to tell me, but I believe I've already done it. If the state agrees with it, then we need to figure out, make sure that the witness or witnesses know.
Sure.
But other than that, that's been done, Your Honor.
Okay. Thank you.
And Your Honor,
Yes.
while we're on this topic, just an additional issue. Not only are there Bruton matters, but there's also just typical evidentiary rule matters, such as speculation. At one point, Mr. Kendrick is asked who he thinks may have done this, for instance, and he names some names. That's the sort of thing that would need to come out, Bruton or not, if we're asking about speculation.
Okay, well, it sounds like it's not going to be played as sort of a running statement. It's going to be more targeted questions to the, I guess, investigator that conducted the interview.
Correct.
Okay,
So
so,
that would not even be an issue, putting in or trying to redact out
okay,
those kind of comments.
all right, good. All right, so let's turn to some of the,
Okay, this is eating my battery. All of a sudden, after 20 minutes, I now only have just over 1 hour of battery left. So, yeah, let's get as far as we can.
specific then evidence that's going to be coming in with these next witnesses. So there's not anything controversial with regard to witness Burnett's evidence, right?
Playing in 1.5 so we get through as much as possible.
And everybody else is silent, so I'm going to take that as a no for everybody else. All right, so Mr. Sledge, there are some co-conspirator statements from him.
All right. we have covered most of that co-conspirator statements, which I believe is BS. So we can skip forward a bit. Mander says, did they review the motion that was filed to limit the state's case and witnesses? Yes, somewhat. At the end of the day, they did. And yeah, Ms. Love said, well, we have already gone from 700 to 200. We have limit ourselves. And Weinstein then told the judge, well, this is more putting a time limit on the prosecution so they don't extend everything as far as humanly possible. And Love said, well, we don't plan to. And well, it was brought up that every witness they have ever called has gone a lot of time. But yeah, we can only hope for the judge's discretion.
We already did his interview, right? Okay.
Yeah, let's skip ahead a bit because this was not that interesting, but except this part. And why is that? Well, you know it, folks. You know it. It is sidebar counter 222. All right, let's move on. Let's see, where were it? Let's check this out.
In cussing.
Yeah, this is the somewhat unrelated according to the defense. And the prosecution argues that, well, it shows that they are in cahoot with each other.
Judge, this video. If the objection is relevance.
No, I am north of Indianapolis.
So if the court was able to hear what was being said, this was a public declaration by a YSL member on his social media page that it is Big Crucial. They're at Big Crucial, which is Club Crucial. The substitution of the C in Crucial for the B is evidence of what our gang experts have testified to regarding what blood gang members typically tend to do. Mr. Zachary is referencing not only himself, but slime takeover at Big Crucial, YSL. They're using YSL jargon. It is evidence of the existence of the enterprise, the existence of the
yeah, but they have played so many of these, so very, very many of these. And they showed pictures and social media posts. It's ridiculous to keep going with it. Let's skip ahead a bit more because apparently since it's the usuals plus a few new ones in that specific video, and that makes it relevant apparently. See.
If you hit play, the first person you see as they're talking about YSL, Big B, little bitch, is Quindarius Zachary. So
yeah, and that apparently will be a witness going forward. Let's skip ahead to after that break.
All right, we're looking at the social media posts for Mr. Sledge. Which ones do we need to litigate? So for whatever reason, I don't seem to have let me see if I can find the numbers. They were a lot clearer on the last group. So give me a minute to find where number 3 is.
And Judge,
Yeah.
Am I incorrect? I believed that we had gone over Mr. Sledge's social media post. We did not?
I don't know if that happened.
I thought that we had gone over them,
Sort of.
some of them at least, and particularly number 3, if that's the one that's labeled State's Exhibit 397Y.
397Y. No, I've never seen that.
Where we talked about the fact that it was the night of Donovan Thomas's murder and that he was
Yes.
posting.
Yeah, I
Patriots
remember
Day?
talking about it.
Okay.
We haven't reviewed this, and my objection to this is the state keeps inserting these January 10th, 2015 captions on these photos.
We don't,
If you look at every other Instagram photo, there's nothing like that. But then on these January 10, 2015, they're inserted, and that's inappropriate in my estimation. And that's my objection.
Sustained. I don't think y'all need.
Yeah, and again, this is what the prosecution does. They do all these small things all the damn time in the hopes that it won't be caught. And sometimes they succeed. This time they didn't. And it's every little thing of this. I mean, at what point do you have to realize it's not a mistake? At what point do you... My point of that is somewhere in June of last year, but there are a bunch of people who are completely new to this trial, and you are most welcome. I have roughly 140 streams and videos about the Young Thug trial. So if you have a couple of weeks with nothing to do, yeah, let's skip over this. Skip over the music part. Oh, this is eating batteries. I'm going to the end of... Let's see, where is it? Yeah, after this one. So we can catch us.
Would be to discuss the state has noticed a number of intrinsic acts.
Okay,
I think the group would like to discuss that. if
that's
it's all the
fine.
same
I mean, we got to
everywhere
get through all of it, so I don't really.
Yeah, intrinsic act, or whatever it's called. These are the ones that happened in jail and in the courtroom. And this is really interesting. It shows me these are the... Here's the thing, folks. It doesn't really matter if only one or two of them gets in and the jury sees, oh, they are committing crimes in court, in the courthouse. That's bad, folks. That's really, really bad, because everything else from 2013, 2014, 2015, and 2016, there is basically zero evidence. With these things, they are on court camera allegedly doing stuff. That's bad, folks. That's really bad. That's really, really bad. I hope on Friday, on the Friday panel, I can get Doug on so we can get more insight on it. I will have Phil Holloway, hopefully, on Friday. Talk to him earlier today. So on Friday, the Friday panel show, the usuals will be invited, with the addition of hopefully Phil and Doug this week, because we have a lot to talk about.
And if we do it in a different order. Okay, let's do that. Oh, and actually, Miss Hilton, you had said you wanted to put something on the record about, I think, Mr. Huey's motion limiting about the, I assume it was the one about the photo ID from the deceased witness. Okay, what's your announcement?
Your Honor, the state does not intend to introduce that photographic lineup
Okay.
or the interview itself. The state would ask if a photographic lineup occurred and would ask if Mr. Howland was interviewed, but not the substance of what happened with either of those items.
Okay. Does that cover it?
So, Judge, good afternoon. It does cover it, Your Honor. I'm concerned on asking the question of whether or not one was occurred would make, I don't know that that would be necessarily relevant, or it kind of implies that perhaps there was one, but we're not getting into it. So I'm not sure the relevance of asking that question. Maybe the state can shed light on that.
Sure, Your Honor. I believe that we still have to show the credibility of our police officer conducting an investigation. And so I think that it'll be relevant that he conducted an investigation. That was a part of the investigation.
All right. Yeah, there's often an argument that the police didn't do it their
He conducted an investigation as a part of the investigation. Oh.
investigation. They already had people targeted, and that's all this is. So if, to the extent that it might go to combat that, then I will admit that over the relevance objection. That I will permit that question, and the rest of it, their concede should stay out.
So they're not going to ask, they'll ask that question, but they're not going to ask about whether or not there was an interview of Mr. Holloman.
Well, I think what she said she intended to ask was, did you interview him?
Yes. Did you interview him?
And whether or not there was a photographic lineup.
Are you going to ask that? I would
didn't hear
think that that's not, we should probably stay away from that.
I didn't hear it because of the mic.
Are you going to ask whether there was a photographic lineup with him, with that witness?
Initially, I was, but based on what the court just said, no. Then I'll just ask, was there an interview? And then we
Okay.
that.
that would be the far safer route. Okay. Okay, so y'all want to move on to intrinsic X. Okay. Which one?
Sorry, folks, I was muted. I said that I'm not a fan on how the judge gives small pointers to the prosecution on what they should or shouldn't present and in what way. Because the three people there on the desk have almost 40 years combined as prosecutors. They should know this without the judge's help. If they make mistakes, then so be it. Then so be it. Yeah, I muted myself earlier. Sorry. As Kiana Shaw said, yeah, it's a continuation of Glanville. It's not as obvious as it was with Glanville, but it's still there, and it's really, really annoying.
Because there was a set that y'all said there just hadn't been a 403 analysis on yet. And then there was, I guess there were a few that at least somebody, Mr. Ryan was maintaining, were not really intrinsic.
Yes, yes,
Okay.
Your Honor. That's accurate. Back in 2022, the state filed a general notice that they were going to introduce intrinsic evidence.
Mhm.
We then got a witness list on July 31st, which I think was supposed to be one of the final, we can rely upon this witness list. And within that, there were 4 incidents which happened in 2023. So they want to post date that notice too. They post date the indictment. So we've
Mhm.
never received any sort of notice from the state saying we are seeking to admit this as intrinsic. However, that is what it is labeled as
Okay.
on the witness list. So that those
All
are
right.
what we take issue with.
Okay, got it. And these are the incidents that occurred in the jail generally?
One in the jail, 3 in the courtroom.
Okay, thanks.
And Judge, I think, I'm not sure if Ms. Bassi realizes that we did notice 2 of the ones that occurred in the earlier part of 2023. The stabbing of the person in the jail by Mr. Ryan, Mr. Blaylock, and others, as well as the violation of the Georgia Controlled Substances Act by Mr. Williams and Mr. Adams. And those 2 occurred on January 31st, 2023 and January 18th, 2023, respectively. The filing that we noticed the defendants of those on was November 6th, 2023. There were 2 additional acts that occurred in 2023 during the time that this case has been ongoing. And one was the drugs that were found in Mr. Stillwell's cell. And we've noticed some of the pictures of the drugs and the other contraband, and the marijuana that was found in Mr. Ryan's pants.
Also, something really, really annoying here is that that wouldn't have happened if they weren't in jail. People who are in jail conduct themselves quite differently from the outside world. So in my personal opinion, if they are supposed to do something with that happened in jail, that should be completely separate from this trial. Because if they are freed from every charge, that means they have been innocent until proven guilty and weren't proven guilty. And then everything that happened in jail should be just crossed over because they should never have been in jail. That's logic.
When he was searched in the courtroom.
Mhm. Okay, so the stabbing, that occurred in the jail, right? Okay, and then the VGCSA violation was in court?
It was.
The drugs in Mr. Stillwell's cell was in jail, right? And then the marijuana in Ryan's pants was in court. Is there another incident that occurred in court?
Not that's on here.
Okay. Ms. Abassi, you had said 1 in jail, 3 in court.
I'm sorry, Judge, but
2 in jail, 2 in court. Okay. Okay. And the argument as to each is that this is not really intrinsic?
yes, Judge.
Okay.
It doesn't fall into any of the 3 categories which would classify it or qualify it as intrinsic.
Okay.
Here it is.
Let me pull out my case law on that. Which, let's do that.
Yeah, and as C. Melson says,
All right.
Stilwell can be a
What is-
dealer.
What's the
And
state's position on why and how that is
also a
intrinsic?
cellmate.
The Bussy stabbing, which is the one I'll start with, Your Honor, involved
I'm
YSL.
sorry, what'd you say? The what?
Oh, I'm so sorry.
I just didn't understand what you said.
Understood. The victim in the January 31st stabbing, his name is
Okay,
Harold
all
Bussy.
right.
and that's
Bussy,
what it is. So that stabbing involved several YSL gang members stabbing an inmate at Fulton County Jail who was alleged to have messed with Rodelius Ryan's commissary. It involved, among others, Demise McMullen, Javon Fleetwood, Christian Eppinger, Damone Blaylock, and Rodelius Ryan. They all, in concert, held down this person and stabbed him repeatedly, all to protect and to vindicate something he had done to one of their fellow YSL gang members. It's the way that I
Okay.
see it. So that it seems just, it's what we've alleged in the indictment that YSL members do. They work to maintain individuals ready and willing to preserve and protect the reputation, power, and even the territory of the enterprise through the use of violence.
Okay. I understand.
With respect to the law, we would cite Johnson versus the State of Georgia Supreme Court case decided September 21st, 2021, cite 312 Georgia 481. And we cited this last week. The Penn site is 491 to 492 in support of it. Okay. With respect to
Cheers.
the January 18th violation of the Georgia Controlled Substances Act, this is 2 YSL members on trial for conspiracy to violate the RICO Act through drug distribution, drug use, drug possessions. And while in court on trial, they are passing Percocets one to another. And we argue one to the alleged leader of YSL while in open court. One of the assertions that we make regarding the conspiracy. We have contraband in the jail. We have stabbing in the jail of YFN Lucci. We have communications in the jail. These types of actions on the part of the defendants are the type of actions that we have alleged in the indictment, and it shows that the enterprise flows from the streets to the jail to the courtroom, and that the conspiracy is ongoing.
And what exactly is the evidence you would be introducing on this VGCSA?
The video of it.
And what all this, I mean, maybe I need
The
to,
video
what does it show?
shows Mr. Adams going up to Mr. Williams while on a break. He's appearing to dap him up, if you will. Mr. Williams puts his hand up under the table. One of our lieutenants goes over to Mr. Williams and sort of says, "Give it here." Mr. Williams brings his hand out from under the table, relinquishes the Percocet to him. And later, Mr. Adams is searched. And I think more Percocet pills, more drugs are found on Mr. Adams.
But
And the
that was
drugs, the photos and
Okay.
and
tests of those
contempt of
drugs.
court and everything. So
What's next?
I
So
have
marijuana
talk about
was
that, because I
also,
believe Judge Whittaker, Judge Glanville,
so Mr. Still,
with his Judge Glanville, with his rulings in the contempt of court, that's already handled. It should be. So, yeah, I have to check with Doug about that.
well, sale. There was, on March the 29th of 2023, there were drugs found in Mr. Stillwell's cell that consisted of ecstasy, pills, I think contraband, was it cell phone? A contraband cell phone, for him to have gotten those drugs into the jail while he's on trial for
Yeah, but that's
involving narcotics and the enterprise and the sale and distribution of drugs through that enterprise. we believe is evidence of the ongoing conspiracy.
Okay.
Okay.
Another,
What God?
And then the last one, I guess, was the marijuana found on Mr. Ryan. Give me a little bit more background about what your evidence is going to show on that one.
that Mr. Ryan, while sitting in court, I believe deputies may have smelled the marijuana
Okay.
on Mr. Ryan. And when they went back to try and search or to figure out where the smell was coming from, a large commotion was made. And the deputy,
By large commotion by.
Mr. Ryan, and the deputies found the marijuana attached to, I think, his inner garments.
Okay.
We have the video.
Okay. We don't know how it got there.
I
I mean, on the Percocet, you got an alleged gang member providing it, right?
yes,
So how about, we don't have anything like that with regard to the marijuana?
we don't have
We
who
just-
provided him with the marijuana. No.
Okay. All right.
I don't know how pertinent it is that we have one that's not on here that is also involving drugs that are brought into the courtroom and provided to another YSL member, but that particular one has been severed, so we don't have that one
Right.
on here.
Okay.
Right.
I think that the first three that we talked about are, I can see how those would be intrinsic to showing the allegations that, this is a continuing, ongoing RICO enterprise. Mr. Ryan being in possession of marijuana when we don't know where it came from, that one, I just don't see that following within. I mean, it shows, what it shows that he's in.
Well then, Judge, there are a lot of similar things in this trial that are equal. We don't know where that came from, as the guns that some people allegedly had. You can prove that they were provided by other gang members, except for a bunch of snitch people. And so, yeah, so what? Because if the judge applied this standard on the rest of the trial, there would be 90% of all charges they can do a directed verdict about immediately.
Possession of an illegal substance, but it doesn't, I don't think it's intrinsic. So I'm going to rule that one out.
Yes, Your Honor.
The other three,
Your Honor,
yes. Go ahead.
I appreciate the directed verdict that you just gave for one of Mr. Ryan's.
Oh, is that
intrinsics.
one of his? That's not something.
No. I'm saying,
Yeah.
you're
That's
keeping it
not
out
anything.
without hearing, but from us. But regarding Mr. Stillwell's,
Mhm.
we have an indictment with 100, I believe it's 191, could be 191 over X.
Yeah.
Okay. We also now have a list. At first, we thought maybe they had abandoned these 53 and they were narrowing it down to 4, but no, it's 53 plus 4, 57 plus 191. That's 248, I believe, 248 uncharged events, or not substantively charged
Right.
events in that are coming into this trial. Regarding, the state keeps saying, and this shows the enterprise. Okay, there were apparently, I've seen photos, I wasn't there. There were pills that were recovered from Mr. Stillwell's cell, where he has a cellmate.
Okay.
Okay. There is absolutely nothing about those pills that suggest they were provided by anyone associated with YSL. There's absolutely nothing that suggests that those pills were going to anyone associated with YSL. There's absolutely nothing to suggest that any proceeds from those pills were being provided to anyone in YSL. There was a phone. I have not received any information from that phone that suggests any link at all to YSL. I am not saying my client's a drug dealer, but what I am saying is people that are in possession of drugs, whether it be my client or his cellmate or someone else, are able to sell drugs without being part of a huge enterprise.
Mhm.
And without any evidence that somehow this is linked to YSL, this isn't intrinsic. The test for intrinsic is an uncharged offense arising out of the same transaction as the charged offenses. I don't believe that's the case. Evidence necessary to complete a story of the crime. That is definitely not the case in this scenario. And it's inextricably intertwined with the evidence for the charged offense. I don't believe that's the case either. So
Well,
I don't know why this
I
is.
understand. Thank
And,
you for.
and just so you know, Your Honor, he is charged on a separate indictment. I believe it's indicted. If not, it's in a CP case still, but he is charged separately. And that case is pending in Fulton County Superior Court.
Okay, appreciate it. Thank you for bringing my attention to that.
Your Honor,
Yeah.
if I may a bit further, the one case,
On which?
really regarding all three of them. I'll
Okay.
start specifically with the stabbing as the state did.
Can I rule on this other one first? Give me just a second.
Which other one?
The one that Mr. Sharp was
yes,
just
yes,
talking
Your
about. Okay. So the
Yeah.
Stillwell had a cellmate. Is there any evidence
Williams-
as to where the
Yeah.
drugs came from, or that it was his, or that the cell phone was his, or connected in any way to YSL?
Well, two things. So yes, we believe that. I think we have to do body cam research. we believe that the testimony from the deputies within the jail would establish his ownership of it. But more importantly, what we have, I briefly touched on it, was the other YSL member whose intrinsic act that we've not put in here. The pills, if we call them purple hearts, blue stars, and yellow diamonds, they were trafficking amounts in Mr. Stillwell's possession, and they were trafficking amounts in the other YSL members' possession. That is not.
If there were 10 pills of each, I have no idea. No, because he knows he will be in jail for a very long time. Almost any amount in when you are looking forward to another year in jail are for personal use. So but they have to argue this because this is the most solid they have had on anyone this entire trial.
Not on here, and that has been severed. They are the same type of pills, and they are a large trafficking amount.
Okay, but
Similar, the same.
And we know that at least that other one, that other YSL member, smuggled the drugs into the jail, or at least into that area, through the courtroom. As it was described, it was enough in one, it was a pharmaceutical.
okay, so any evidence that what was in Mr. Stillwell's cell came from that?
Other than it was that they were just alike. If you looked at photographs of it's not like you had all white pills. Like you had the same array,
Blue, purple, and
to use just some colors. Like they were literally at least three different colors and three different shapes of pills. And they were the same, three different colors and three different shapes.
and you can establish that those were YSL related?
Yes, because the when you say those, you're talking about the one.
So if I'm to accept that y'all have enough that you can make the assertion that the pills that came through some court proceeding to this other person who's not a part of this trial,
Right.
Are the same that are in Mr. Stillwell's cell, then what's the YSL connection?
Not the same pills, the same
type, the
Yes.
same, shipment or whatever, the same.
that person was in this trial. That person was in this trial during that time.
Okay, but them being in the trial and co-defendants doesn't establish what the assertions are.
No, it's the not similarities, the exactness of the
No, I'm not asking at this point, like, assuming for the sake of argument that, yeah, these pills all came from the same place. And he, in fact, then what's the YSL tie-in?
maybe approach with a member of the.
Sure.
Yeah. This is what happens
I didn't
when
know y'all didn't have.
Ms. Love is faced with, okay,
Oh,
show
yes,
us
you may.
actual evidence.
So are y'all satisfied about, our other bench conference was about the location of that other person? Everybody, I just assumed that y'all.
And dun dun dun, sidebar counter 223. Skip ahead, skip ahead, skip ahead.
All right, I am, with regard to the contraband in Mr. Stillwell's cell, I'm going to rule that out as well. And I mean, he may have another indictment against him at some point in time, and it would all be appropriate to come in there, but not for this case. So that, now, Ms. Abbasi, what
Good work.
do you want to say with regard
Good
to the
work,
other
yeah.
two?
Yes, Your Honor. Your Honor, actually, the state cited when they discussed the stabbing, the same case I cited, Brown, which had, as Mr. Shard said, those three circumstances, uncharged offense, which arose from the same transaction or series of transactions as the charged offense. That's actually the topic of discussion in Brown. And in Brown, it was a robbery which happened 1 hour before the charged crime. If the state is going with it's part of the same transaction or series of transactions, then we have a very serious problem with proximity, because the case law is not anything a conspiracy does that happens over the lifetime of the conspiracy qualifies as intrinsic. It has to be closely linked with the others, closely linked with the other charged offenses within the indictment. Your Honor can look at Sanchez Villa versus State, which is 341 Georgia at 264 from
I like
2017.
her. She's
Within
good.
that case, the evidence the state was trying to present, the court found all of the cases the state submitted distinguishable. And the same is true here when Your Honor goes through the cases.
Okay.
As far as being part of the same transaction or series of transaction as the charged offenses, this, like those cases, is attenuated in time. For ones which do have more time in between, they discuss how in those cases, the defendants in their other uncharged acts were in the exact same role. So in one, it was trafficking cocaine as the lookout. In the uncharged, trafficking cocaine as the lookout. There were very specifics linking them.
Were any of these in the Sanchez via either those facts or the cases that are distinguished, either a RICO charge that was involved or a gang enterprise?
I will double check because they go through quite a few cases. I'm going to have to look back through all of them. I think the hallmark of it that we get within Sanchez after they discuss all these cases, the evidence in this case, the Sanchez case, is considerably more attenuated in time and space from the events leading up to the charge offense. So it offers little to help the state. They continue on and say that, well, as far as this goes, we're not in a circumstance of completing the story of the crime. This is just expanding it.
Yeah, I mean, right. It's a different crime, but it might have been a different thing if they were charged with a RICO count in Sanchez. So that to me is what, if these were just whatever the other charges in the indictment are, then I would say, no, but it's the kind of enterprise nature and the ongoing nature that.
And I certainly understand that, Your Honor. I think, however, to say, well, it's part of the conspiracy basically opens the door to anything any defendant allegedly who is a member of YSL does, then automatically becomes part of the conspiracy and automatically comes in simply because it is intrinsic.
Okay.
I think with a lot of this, Your Honor, we're getting close to some due process concerns here. The defendants are on trial for the offenses they were indicted on. That's what they're on trial for. They're not in trial for the enterprise continuing in 2023, that it was still ongoing. That's just not relevant. If the day after indictment, every one of the defendants got together and said, whatever our group is over, and it was completely disbanded and no longer continued to exist. That wouldn't be relevant either. What they're indicted for is what they're on trial for. So here, we're expanding. That's, I think, a lot of what's happening with our social media and other things that I guess the state has found afterwards. They're now being tried for things the grand jury never heard about. And that specifically is a violation of due process. I can supply to Your Honor the U.S. Supreme Court case law.
No, I'm with you on that one. And I am very skeptical of the state's argument that any uncharged, not showing up in the indictment overt act that they offer could in any way support, if found, a RICO count being established. So unless I hear otherwise, which I don't want to hear otherwise right now, we'll take that up another day, but that's not our issue right now. But yeah, I think the state's got some convincing on that count. But with regard to whether, it's intrinsic, I want to get it right. I want to follow what the law says about it. So I think that the key issue here is if we're talking about RICO or we're talking about, a gang enterprise kind of thing. So maybe we could all do a little bit more research on that.
I did look at in the state's original notice, they cited a proposition, I believe that was cases have been in gang and conspiracy prosecutions, gang and conspiratorial activities have been classified as intrinsic evidence. They then cited a number of other cases. There is not one single case I can find in any case at all where the intrinsic actions come after the indictment, because that's the touchstone of it being intrinsic, that it really is all one thing, that the story doesn't make sense without all of these pieces. And these things hadn't even happened yet. So it's not possible that they could be essential.
Let me ask you this. If, for instance, and this is entirely a hypothetical, but if this group got together and stabbed this, whatever his name is, Bussy, not because he messed with Mr. Ryan's commissary account, but because he was going to be a key witness in this case. And they, I'm sure the state, if in this hypothetical, would argue we're trying to send a message that he better not be a key witness in this case.
But that would be witness intimidation, which is a part of the ongoing trial. So the hypothetical here is completely bonkers. It's not even in the same world. They fought over stolen lunch money. Has nothing to do with YSL. That's not. And the guy is 15 years younger than them, as I understand. They wouldn't even talk to the kid. I mean, no, just no. I mean, the hypothetical doesn't make sense to me because the situations are so far apart.
Would the argument be different then?
Well, yes, it wouldn't be. They wouldn't be trying to admit it as an intrinsic act. It could be a crime in and of itself.
No, we're not talking about then they get separately indicted. We're talking about they're in the middle of this trial. This happens. It's not obviously set forth in the indictment because it just happened.
It would be 404B and probably fall into a category there, which would make it admissible for a basis which was not character. It just wouldn't come in as under intrinsic.
Okay, so you would still make the same argument that it couldn't be intrinsic evidence, even for that, because it occurred afterwards.
Based on the definition I've seen of intrinsic, I don't think it's possible for something which comes after to be
Okay.
necessary to complete the story, unless the story wasn't complete at the time of indictment. That's fundamentally unfair to try them for something which hasn't happened.
Okay, they're not being tried for it. It's,
Correct.
but okay.
Based on
All
your
right, well, I mean, y'all try to find me some more on-point law on both sides, please, if you could. So
Yes.
maybe that'll be my preliminary ruling, subject to revisiting, okay?
And Judge, there was one other thing. I don't know that it'll have any bearing on the court's ruling, but in that instance where Mr. Stillwell, where the drugs were found in Mr. Stillwell's cell, there were, Miss Hilton pulled up the photograph that I asked her to, and there was a shank.
Is the shank inscribed YSL?
No,
It doesn't,
no.
I mean, it makes Mr. Stillwell look bad, but it's not intrinsic.
Yes,
Your Honor,
Yes.
if I may,
Yes.
before you make a decision on the one alleged intrinsic act that was referenced by the state involving the supposed passing of a Percocet pill from Mr. Khalif Adams to Mr. Williams, I would ask that the court at least go and take a look at the video that was referenced by the state. I think it's instructive. I also think that well, fortunately for us, paints a different picture than was recited by Madam Prosecutor. I think the events did not occur in the manner that she referenced. I was present. I was sitting right next to Mr. Williams. I think the video will show something being passed to Mr. Williams, not him hiding his hand underneath the table or bringing it out and then giving it to the deputy, or the deputy saying, give it here. It didn't happen that way. And I think that goes into the analysis of exactly what happened.
All right, why don't you just tell me what you recall or what you think the video shows?
Sure. Well, what I recall, and what I know happened, because I was
Okay.
sitting right next to Mr. Williams in the front of the courtroom, is that it was a break. Mr. Adams, who was sitting in the rear part of the courtroom, came up, and as he was going towards that door, goes as though he's going to give Mr. Williams a high five or a dap or something like that, and put something in his hand. There's a deputy who's standing about 2 feet in front of Mr. Williams. Mr. Williams looks surprised. Mr. Williams has it in his hand and puts it down on the table immediately. There is no putting hand under the table to try and conceal it. The deputy, who I was within earshot of, did not say, give it here. Mr. Williams looks at it and puts it down on the table, and that's it.
Okay.
And at which point, another deputy sees Mr. Adams and either takes him. I don't remember if they took him in the back or brought him back here.
Okay.
He was searched in the back, as I understand it. I think court recessed after that because of those occurrences. But that's how the incident actually occurred.
Okay, can y'all send me that video?
yes, and
Okay.
the deputy, the lieutenant
How about
would
that?
also be a witness
His love
to what I'm saying.
All right, well, I mean,
The version
I would
of it.
imagine the video shows what happened. So.
It does.
It does indeed speak
All
for
right,
itself.
well, we'll come back to those two.
Yeah.
All right, so that takes
No,
care of the allegedly intrinsic, but according to the defense,
Yeah.
can't be intrinsic because they happen later in time than the indictment acts. What about the other intrinsic or allegedly intrinsic acts that there has not been a 403 analysis on yet?
Can I just add something to the last? Your Honor, can you ask what the prosecutorial need for this is?
I can, but with intrinsic acts, that's not part of the analysis.
Yes, 403 is the
Well,
analysis,
403,
which
So-
includes prosecutorial need, waste of time, prejudice, substantial prejudice outweighs any probative value. But to me, this is a big case. It's
It
been around a
is.
long time, and now intrinsic acts. So yes, I
Okay.
don't know how much the state needs to prove that Mr. Williams was knowingly or unknowingly given an alleged item. I'm not so sure what the crime lab came back, but I can't answer for that.
has the crime lab come back?
That may be true. I don't know. I don't remember.
All right, so we now have a 403 argument or objection.
So, Your Honor, I think that the court had it right regarding the need to analyze, looking at the prosecutorial need. If it's a 404B act, then that would be a situation where we would be looking at the prosecutorial need, but it's not. We're alleging that it's an intrinsic act. And looking at 403, Your Honor, the analysis is it substantially more prejudicial than probative? And it's simply not, is our position. He's alleged to have, Mr. Williams and the other indictees here are alleged to have conducted drug transactions. One of the acts on the indictment involves
I hope she was.
Them having a trafficking amount of drugs, right?
And
at
then
least
as-
one. So we would argue that it in no way can be viewed as substantially more prejudicial.
I hope your critical watches that video and then addresses Miss Love with, why did you misrepresent what happened, Miss Love, Prosecutor Love? Clearly, your description of this is nowhere near the truth. Why are you making things up? Will that happen? No. But we can always wish. We can.
Judicial than probative, and it's intrinsic. But we're pulling up the video too.
Well, I mean, I guess is it intrinsic is yet to be determined based on the time period, but
Your Honor, this
Yes.
is not really my argument, but I have got to weigh in here
Oh,
on
please
this.
do.
Yeah, thank you. I'll get my 5 minutes in. The 403 analysis is not limited, as you know, to is it more prejudicial than probative.
Mhm.
As Mr. Steele said, you also have undue delay and waste of time. And those are factors as well that I'm not surprised that the state ignores, because they seem to have no concern for delay or waste of time. So those are factors that the court should consider as well, Your Honor.
All right. Thank you. Okay. Well, I will give y'all a couple of days to, if you can find more on point law, provide that. And if not, I'll just have to go on what we've got and make a decision. I'll take a look at the case that got cited and the cases within that. And then if need be, do the 403 analysis. I may not get to that, but okay. So that's those. What about the other intrinsic acts that 403 hasn't been done on yet? Do y'all is there a list? And is it? And I can't, let me see who, I'm not sure quite who filed that one. Or maybe Mr. Sharp just told me there are some that the 403 hasn't been done on yet. From the November 6, 2023 filing, but I don't know which of those.
And some of them have already been, so Judge Granville made an initial ruling on one day on 1 through 3. And then throughout the trial, we dealt with and admitted evidence on number 4. Does the court
Not right in
I'm
front
not
of
sure
me.
what list you're referring to.
the filing on November the 6th, 2023?
Yeah, I think
Of
I've
the-
got that. Give me a second to locate it. Okay, yep, I got it.
So, Your Honor, my recollection is that we began discussions on this one day a long time ago.
Okay,
And I agree with the state that they have presented evidence on some of these incidents, some of these acts. Your Honor is saying that we haven't done a 403 analysis. I don't believe
only
we've done.
because y'all, that's what I thought you had said to me.
Okay, if I said that, I believe I misspoke. I don't believe we've done really any analysis on this list. Meaning, I don't believe, speaking for the people on this side of the room, I don't believe that we are conceding that they're intrinsic.
All right, so we may need to, starting with number 5, look at all of them.
Like, Your Honor, I thought we were going by the state's July 31st witness list. So that would not encompass all of these things on here. That witness list went through by what offenses it was set to prove. or
This
acts.
one?
Yes. So I was relying on the witness list when filing motions in limine of what they actually intend to prove. I thought that was the whole purpose of.
Well,
Judge, I'm not sure if Ms. Abbas, we filed this November
Yeah.
the 6th of 2023, and I know she wasn't here at that time, but we, this is the argument I think that Mr. Sharp made. This is the one that he sent out with his objections. This is the filing. So this is the one that we're addressing.
okay, well, I mean, if for instance, you don't intend to use, 20 through 30 anymore, tell us that. If you still think you intend to use every one of them, tell us that.
A lot of them have already been completed, and there have
Okay.
been testimony. There's already been
All right.
testimony on a lot of them.
Okay, so can you tell me right now?
Yes.
Which that's true for?
Number 4, the 5/12/2013 aggravated assault and home.
Yeah, I mean, I've got it right in front of me, so if you just want to say number 4, that's fine.
Number 4, number 5.
And you said a ruling had already been made on 1, 2, and 3?
Yes,
Okay.
we didn't admit them, but they were. Okay, so we did not admit evidence of 1, 2, and 3. We, all that we did was address them initially. We didn't admit evidence, and we don't intend to, but those were the only 3 that were addressed initially.
And you don't intend to, so you're not intending to introduce those 3?
Right.
Okay, well then we'll cross 1 through 3 off the list. Okay, 4 has already been admitted, 5 you said has already been admitted.
Right.
Now what?
Also, as it relates to 7 is one of the overt acts listed. The reason that we included it here is that Shannon Stillwell's name was not in the indictment itself.
I was traveling and listening, and then me and Mo did the live from Delphi, Indiana. We actually went to Delphi, Indiana, and then I tried to listen some more after we did that, but on the road. So I've heard it. I might not have listened to it. Let's continue while I still have battery on my laptop.
Okay.
On that overt act. The same as to number 8. What? I said the same as to number 8.
Okay, so those are listed, those acts are listed as overt acts, but Mr. Stillwell is not listed in the indictment when
Right.
you're talking about the overt acts. Okay,
Correct.
all right. What about 6?
6, actually, we so
Yes, love.
6 is going to be talked about. It has already been talked about some, and it'll be talked about some more.
Yeah, I thought it had already been talked about some. So I mean, that's in the past, basically. 7 and 8, given that they're overt acts. adding Mr. Stillwell to them, that can still come in as intrinsic. What else?
10 has
How
already
about
been,
9?
9 has not been talked about.
And do you intend to still present evidence of that? I mean, you do at some point need to streamline your case.
So,
Yeah.
so we can strike off number 9.
All right.
I believe. 10 and 11 have already been alluded to, and in fact,
One thing I need you to remind me on Friday, because I don't know if I will remember it, is the fact that they held a Daubert hearing in front of the jury. I've never seen that. I honestly believe there is no case law anywhere, and no law or rule that allows a Daubert hearing to be conducted in front of the jury. Daubert hearings are specifically designed to be done pre-trial. So remind me to bring that up with Doug. Thank you. Let's continue.
11 has been discussed by the witness who's coming
Okay,
on.
so those are already in.
Yes, and I think that the court at first asked me to tell the court which ones that we.
Well,
already-
you know what? Why don't we just walk through them the way we're doing now? Because you might decide on some other ones that you don't need those.
All right. So Hill Street there will be testimony given on that through Detective Dennis.
Okay. And
Oh,
he's
he already
involved in
talked about
that.
it. Ms. Hilton has
Okay, so
reminded me.
that's already in also. Okay.
Number 13, a witness has already talked about,
Okay.
Mr. Copeland on the stand. Number 14 has already been testified about.
Okay.
We've
Need
taken
as
off
well
number
as doing
15.
talk to text.
Number 16 has already been testified about. Number 17 has, we've already presented evidence on.
Okay.
Number 18, we've already presented evidence on. Number 19, we intend to present evidence on.
All right. And tell me, is that like part of the gang rivalry leading up to Mr. Thomas's? I mean, I'm just looking at the date for that. Or why is that intrinsic? Why is that a part of the whole story?
Already.
We've talked about it, or y'all have talked about it.
She's right. We did.
I'm not aware.
The aggravated assault at Trestle Tree on the 8th.
What case is that?
The aggravated assault at Confederate Court
I'm aware of that, but
through Detective Dennis. I believe that when he gave, I'll have to go back and make sure, looking at our,
No, that hasn't
at
been
the flip
talked
chart that
about.
we made
Yeah.
while he was on the stand.
Okay. But would this be part of the back and forth that y'all assert led up to?
It was part of the shootings that they went back after the murder of Donovan Thomas and found out about. So that when we say back and forth that led up to it, they started investigating those shootings after the murder of Donovan Thomas.
Okay.
And this was one of the ones that
And this is a shooting of him by him.
at Trestle Tree, which would have been Ifgang territory, we allege by.
For you who don't know, that is one of the reports that the prosecution hasn't been able to present to either the court or to the defense because it's not there. So they have this hack investigator on the stand testifying both as a fact witness and as an expert witness about things he more or less remembers. That's not how it's supposed to be done.
YSL members.
Okay. And what evidence do you have of that?
Hi, Gigi.
Okay. Sorry. And just so that Mr. Sharp has that, it's for 150080094. We've already put the CAD report in the 911 call. In.
okay.
Okay. Well, that pretty much
Well-
sounds like that's in then.
Well, I don't agree. I mean, what's I think obvious right now is I've been very involved in this case.
Mhm.
I don't know what this January 8th shooting is. I'm asking Miss Love. She doesn't know. So I'm trying to figure out how anyone could argue, if no one even knows what it is, how it's so intrinsic to this case.
Yeah, I don't know if she doesn't know what it is.
Well, I
period,
mean, I
or
can
if
actually-
she
I'm
just
giving
doesn't
up.
know right now what it was. So who is alleged to have done this? So, or is this just a general, we, the gang experts, found out about this and we think this was a part of it? So, okay. Is there going to be more besides what's already been
No.
testified to? Okay,
No.
so it's already in. Okay.
Number, what number?
20.
By testimony, not by
We have already
actual
heard testimony
evidence.
on this one.
And that's all we're going to hear as to
Yes.
that? Okay.
Yes. And we've already heard testimony on 21
All right.
and 22.
Mhm.
We're not introducing 23.
Okay.
24, we've
We have a half
heard, we've
hour,
already heard testimony about,
40 minutes of.
and we will hear more. This is actually where we got that video from that we mentioned, Mr. Sledge, that's in the folder for Mr. Sledge.
Mhm.
Number,
So, hang on. What else is going to come? I mean, great if the video happened to be from there, but what else is going to come in about this ag assault criminal damage?
well, Mr. Antrevia Smith is one of the witnesses that we've listed,
Mhm.
and her testimony.
That's a victim?
Yes, that's whose house it was.
All right. Okay,
Miss
go ahead
Love,
then. 25?
Miss Love has this thing where she is the human embodiment of the world of doom. She's buffering, and she talks while buffering because she has no idea what she's supposed to say.
This is January the 28th. January 28th. I thought we'd already introduced that. Kendrick's position of firearm on January 28th. 1502.
Okay, skip.
Introduced evidence of 27, we've already introduced. Evidence of 28, we've already introduced evidence of. With the exception. So 28, this Hilton is reminding me that with the exception of Shannon Stillwell's involvement in the Little Wayne bus shooting, it has come in, but it was added here because Shannon Stillwell's name is not on the paper.
All right, that's fine.
29 is coming up. The shooting at Club Crucial preceded the shooting at Adele Drive and Drew Drive, and that's duplicative of 7 and 8. So 30 and 33 are the same.
So, I'm sorry, 33, 33.
I was saying 7 and 8. Of course.
Oh, okay. So they're just listed on here twice, basically. Okay.
34 is already.
So I can just cross off 33, 33, right? Because we've already covered them. Okay.
34 has already been testified about. 35 has already been testified about.
Okay.
I told you. Every time Miss Love is scared of being caught in a lie, she does the Catholic schoolgirl being caught thing, trying to pull the skirt down below her knees. Just, oh no, clear tell. Let's continue.
36, we don't, well, actually.
Yeah, neat as well. I completely agree.
Okay.
Right. I want to check. 37's already been testified about, 38's already been testified about. 39, we don't intend to introduce evidence of.
Okay.
40, we do intend to introduce evidence of.
Okay.
Even if she has
That
trouble,
seems pretty intrinsic.
still does the thing.
41. We were taking out 41, this was Hendricks and stuff. Oh, Judge, I apologize. As far as 39 comes in, I was thinking of another incident. 39 is coming in. That is what led to the arrest by Mr. Kendrick and Mr. Arnold with the firearms that Mr. Kendrick entered a guilty plea to that involved his plea colloquy that we spoke about earlier. But the fact that Mr. Arnold didn't want to identify Mr. Curtis or testify against him at trial is not, we're not putting that part.
Okay, but that Arnold was assaulted by that
Martinez.
you want the whole thing in?
Yeah,
Is that what you're saying?
Yes.
sure.
That is what led up to the arrest
Sure.
of Mr. Kendrick and Mr. Arnold. They went to retaliate. So my apologies. That's 39 and 40 coming in. 41 being taken out. 42, we don't intend to introduce evidence of 42.
Okay.
That's the thing.
43,
Two, which means they hope
43 is coming in. Well, we intend to introduce evidence of 43. That's tied to the armed robbery that he's alleged in the indictment to have committed.
Okay.
On October the 11th.
Yeah.
44 comes in.
Yeah, while you are talking about it in the chat, Detective Gaither, or Investigator Gaither, the world's most incompetent cop, left the force before she could achieve full retirement after 19 years. Allegedly, she was under investigation from Internal Affairs. Allegedly. And so she quit, or got the option to quit. Otherwise, she might have been fired. Then she joined the Cobb County DA's office as an investigator and left after just a few months. And again, for you who don't know, hi, I'm Nick. I do labor law. I see this so often. People who get the option to, you have the option to quit, or we will fire you, and that will look bad on your record, and it will look bad for us. So I could bet money on that somewhere in either Cobb County or in the Atlanta Police Department, there's an NDA laying around. We don't say anything if you don't say anything. And I hope everything that is holy, that the defense will try to get a subpoena out for that NDA. Because I'm sure it exists. I'm very sure it exists. Everything points to it, and I've seen it happen so many times in my line of law. So, yeah. So next time Gaither is on the stand, I hope that somebody in the defense will try to bring that up. I really, really hope so. Okay, let's continue before I run out completely of battery.
And because that, we believe, is the motive for the murder. That is the last murder on our indictment. 45, similarly, is tied to the Shamel Drinks murder. So we would argue and would ask that that be allowed to come in. 46 as well is tied to the murder of Shamel Drinks. As a matter of fact, 47 and 48 and 49 are all tied to that murder. So the ones that we've listed as intrinsic that the court has heard us talk about, for the most part, 90% of them, I think, are part and parcel of acts that have been alleged in the indictment that just didn't include certain aspects that are now listed on this supplement.
All right. Yeah, I mean, there's not a whole lot. Well, what about 50 and 51? Those are the ones that we just talked about. Okay. All right. So other than those two, I mean, honestly, most of it already has come in, or is like, I don't think even arguably not intrinsic to the rest of the crimes and overt acts. So I think the rest of these, not 50 and 51, but the rest of them, unless y'all got some kind of a 403 argument to make, those seem appropriately in. Okay, so it sounds like that settles that, other than those two subsequent acts.
Yes, I'm having a beer, or 3 to be exact.
All right, with regard to the, I think I already asked y'all to do this, but the Bruton portions of Mr. Kendrick's statement, y'all are going to try to get together on that, or have y'all already done that?
But I thought it was agreed that because I listed out what I believe are redacted portions, and I gave the timestamp on the actual interrogation, then the state can say, we disagree or we agree, we could get together.
Okay, but that hadn't been done yet. Y'all still need to do that?
Right.
Okay, well, that's something I think we might get to tomorrow.
As well as we were just served by Mr. Williams a bucket of exhibits. I think he wants to introduce with somebody at some time
Okay.
through a Dropbox link. So we could probably discuss those this week as well.
Okay.
You can, but it'll take about 8 seconds. There's not much to discuss. I added a video, and I specifically wrote what it is, and then I added it to the Dropbox so everybody has the world that Mr. Williams may introduce at trial.
Okay.
So it's just one video.
All right. So do you believe the state will be able to examine whatever portions of Mr. Kendrick's statements they think might need to be redacted and let us know?
Yes, I looked
Okay.
at some of the, I don't agree with them, but I can look at them and have some agreements that they're arguing about tomorrow.
Okay, sounds good.
Okay, Mike.
So
my
tomorrow we'll
laptop-
still need to do that. We'll need to do the PowerPoint.
Okay, my laptop just got into energy saving mode. I don't know how much more I can. I will stream to the bitter end.
You served that one.
Right. So I'd like to maybe take that up tomorrow or sometime this week. I want us to be ready on as much as possible, though, so that if we finish one topic, we can move on to the next one. And then we've still got, I mean, I guess after those two, we just keep moving through the evidence that are in the first 60 witnesses and, figure out any kind of rulings that can be made ahead of time as to those. And that would include Mr. Sprinkles. Okay. And have y'all done the next 30 yet?
We have everything up to 60, but we'll work on the 61
Through 90?
to 90.
Okay.
Your Honor, just
Mhm.
calling this to your attention. Ms. Hilton is correct. She identified specific co-conspirator statements or things that they alleged are co-conspirator
Right.
statements. In reality, we have a lot of different voices here.
Mhm.
I have reviewed all of the wiretap calls
Yep.
that are relevant, at least.
Okay.
But in my opinion, there's going to be no way to litigate those matters other than just going through them. I hate to say that, but we're not going to agree that any of them are in furtherance of a conspiracy, and we're not going to agree that a number of them, we don't even know who Mr. Garlington is talking to.
Okay.
So that is something that I would humbly suggest should be on the agenda because we're going to have to work through that.
Okay. I mean, yeah, I agree. This is the wiretap. We got to get through all of it. So what witness is that going to come in through?
Your Honor, that's going to come a little later in time through investigator Viverito. So this will be probably towards the end when we're talking about the Shamel Drinks murder.
Viverito?
Yes, Your Honor.
Okay, well, if we get through, I mean, it's a big chunk of stuff we have to do outside of the presence of the jury. So it may not be what is first on tap, but we're going to try to utilize our time. So that's something we need to turn to as well.
And to give just a quarter reference, it will be after witness 91. And this is when investigator Viverito comes up, probably her third or fourth time. So,
Have y'all given thought to streamlining your witness list and your evidence?
So Judge, just so the court is aware, early on, I don't know how familiar the court is with the number of witnesses that we initially started out with, but we started out with over 700.
Mhm.
And before I believe Mr. Weinstein filed his first motion to limit the state's case with the former trial judge, the state announced to defense that not only would we actually be asking for an earlier start time and a later finish time, but we actually told them that we had reduced our list from the over 700 to just over 200.
Mhm.
And we've reduced it further. And then after that was when I believe Mr. Kendrick filed a motion to force the state to reduce its list, but we'd already said and done that. So now we've reduced it even further. And I believe that we are at that point where we've reduced it. The delay that Mr. Kendrick referenced in his motion has not been attributable to the state. We have had a number of administrative days. We have had a number of delays that were caused for other reasons that had nothing to do with anything that the state's case entailed. So our case and the length of our witnesses is not prolonging this trial at all. And our position is that we have streamlined it considerably. We continue to streamline it even after our first streamlining that we apprised them of.
All right. Well, all I'm saying is, please try to do what you just said you are doing, which is continue to streamline. And I don't have the entirety of who's saying what to what, but you do have the thing that says what counts each witness is going to go to. Just make sure that you're not being cumulative and that the witnesses you're calling are basically worth calling, that they're going to add something material to the jury's ability to decide this case.
And Your Honor, we have indeed been doing that. I think that the main cumulative objection has come from, as I remember, they've argued, well, they've called a gang expert, 3 gang experts, and that's cumulative, but each gang expert has talked about a different set of information that they have knowledge of. And they also had factual information that they were both fact witnesses and expert witnesses.
But you're expecting 2 more gang experts?
In terms of new ones? Yeah, there were 2 left on the list that we haven't yet gotten to.
Right, so
one of them we may not call.
Okay, well, you would need to be able to express what it is that expert or those 2 experts is going to offer that hasn't already been covered by the 3 that have already testified.
We would.
Okay.
And Your Honor, I would like the opportunity at some point this week, I expect the state to respond to the motion that we filed, but I would like the opportunity to actually argue that in front of you.
Well, I mean, I don't know that I need a response from the state. I also don't need argument from you. I mean, I understand what you're asserting in your motion.
I mean, just today, Your Honor, they say that gang experts, for example, because that is one that we have gone to, that they have not been repetitive. But just today, and I wrote this down because it's just emblematic. Just today, Ms. Love said, quote, our gang experts have testified to B replacing C. So there's a situation there where their gang experts have testified to the same thing multiple times. There's B replacing C. It's constant, Your Honor. And there's absolutely no reason that they should get to run this courtroom. Now, I'm not asking to run it. I'm asking you to run it.
I'm running it.
Okay. And you have the ability to put a time clock on the state. We're way past the time. I'm just going to finish real quick. We're way past the amount of time that we have told the jurors that they will be here. And that is a factor that you can consider. We told the jurors, now I remember 6 months, other people have said we told the jurors 6 to 9 months. We're going to far exceed that. There's any number of reasons, and they're outlined in the motion. If you don't want me to argue it, I won't argue it, that we can put a limit on the state, or you can put a limit on the state.
Okay, I understand what is set forth in your motion. I understand the law. I understand what my powers are as the judge presiding over this case. I understand that cumulative evidence is unnecessary and maybe undue delay and a waste of time. I also understand that the state has a right to present its case and that they don't have to be limited to just one witness per, count in the indictment. They have rights to. So I appreciate what you put forth there. I agree with it.
No,
I mean,
they
it is
don't.
granted. Okay. I will not permit there to be.
Again, folks, the only people with rights in that courtroom are the defendants. Those are constitutional. The rights the judge is talking about are something that courts have made up and are accepted by higher courts. But the only people in that courtroom with actual constitutional rights are the defendants and nobody else. Nobody else has the right to a fair trial. Nobody else has the right to due process. Nobody else.
Excessive, repetitive, witness after witness saying the same thing, exhibit after exhibit showing the same thing.
Well, the relief I requested was to put a specific time, whether it be days or hours or however you want to do it. So if that's granted, I am thrilled.
Well, I'm not sure that I know at this stage, given that we have only not yet gotten through one incredibly long and somewhat painful witness testimony, what that time limit might be. I don't anticipate most of the other witnesses to be as long on the stand as this particular witness is.
That's not the defense's fault. They're still on direct examination. All of that is on the prosecution.
And maybe I can get, maybe let's just ask the state right now, like time-wise, do y'all expect any of your other witnesses to take as long as Mr. Copeland has thus far taken?
No, we didn't expect him to take them.
But Your Honor, this is not the only witness that is
I
taking this
cannot
long.
do anything about what happened before I was the judge.
I appreciate that.
I just can't.
And I'm not asking you to. All I'm saying is that the state's saying that they don't expect other witnesses to take this long. There have been repeated witnesses that have taken weeks.
Okay, well,
And I mean,
let me drill down a little bit more. Okay. So are there any other witnesses that are going to have video interviews that are anywhere as near as this witness?
No, and for any witnesses that have
Oh,
taken
shit.
more than a few days, there have been
Now she's
breaks
lying
and
again.
causes that have caused us to have to take that witness over a period of time longer than we ever anticipated.
And I hope we don't continue to have sound issues, but nobody can do anything about that, although I'm trying to at least get us a reasonable backup, which should have already been in place anyway. But all right, so I'm going to need an answer as to why there needs to be any other gang expert at all in some amount of detail. And y'all have the witness list, just like, you have the state's witness list. So if there's somebody else like the two extra gang experts, that you all looking at the list and knowing the case backwards and forwards think the person who's going to say this, somebody else already testified to all of these same things, then you'll bring it to my attention and we can go through and get answers as to whether those people or those witnesses or those exhibits are cumulative. But I can't know at this point in time. I haven't been in this case long enough yet to see what's reasonable for, a witness to take.
Okay. So I'll be back in a few weeks asking again, Your Honor.
Okay. All right. So I think there aren't any other short things. I'm happy to stay here another hour if y'all like to. Nobody else wants to. This wasn't even a full day, y'all.
Can I inquire?
Yes.
The item that's I think the computer with the headphones on it, is that going to be in front of the jury?
No, that's a ridiculous place for it to be right now. If we end up having to use it at all, and I appreciate the state, bringing it as a potential fail-safe. I think we're going to try while you're doing your oral argument tomorrow morning, somebody is going to come in here and see whether they can even have this be the backup. But it would, as I understand it, we wouldn't be using the video. We would just be using it for its audio output.
So it would
And it would be up against the wall.
Against the wall,
Yeah.
right. That's where we had it.
Like we don't even need the video part, right?
Not necessarily, but it would be showing the Zoom. It would just all be the same
Right.
thing that's
But
on every
the
other
jury
screen.
doesn't need to watch that screen. They can watch the screen they already have available. So we can slide that entirely up against this back wall
That is what
where
we
it's
had.
out of the way and not, blocking anybody's view.
That's
But-
exactly the way.
But we would potentially use it for sound if our sound system continues to go on the fritz. IT tells me they think they have come up with a solution. I don't know whether they have or not. I also don't know how long it's going to take them to implement said solution. So I have asked them to have something else ready. This may be part of it, but yeah, okay. I'm reading an email that just got sent to me by the head of IT about it. Anyway, we'll try to get all of that addressed. Okay, so we will convene Sergeant Ingram on the scheduling. I had said 12. Is that doable, or is 12:30 just a better? Okay, so let's all plan to convene at 12:30 tomorrow. So when y'all show up at 12:30, it'll actually be the right time. And we'll see you then. Be ready to work on and have objections and responses ready for what we've just talked about. Okay, that's all I wanted to know. All right, so we're adjourned for the day.
Let's just see. So, no, nothing else. Okay. With 6% left on my laptop, we got through it. Yes, I could have talked a lot more, but we've all seen this before. The prosecution's shenanigans, how they are desperate in getting new things in all the time, how they blame everybody else but themselves for everything. And Miss Love, she can't stop lying to the court. And this time about that Percocet handover, which clearly didn't happen the way she described. And now my computer is sounding the alarm, so that it's about to be shut down. Okay, folks. Again, thank you for being here. Thank you for allowing me to do this. Thank you for the membership, the super sticker, and just thank you. And folks, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it, okay? I will see you tomorrow. I will be at Dave's place, so it should be easier and better. Hopefully I can do the hearing live tomorrow. Hopefully. Okay. This is Nick, due north of Indianapolis, and you all have a great day and great continuous day and all of that. Yeah, you know it. See you tomorrow. Bye-bye.
I came from Sweden, drives across the land. Steel his grip, axe in his hand. Georgia lives me his fierce eye. Cryptic funny lets out a cry. Battles from east under the southern sky.